panel right here, we're going to hear from intellectual property specialists who are going to discuss the latest IP strategies and resources available to entrepreneurs. Now, to moderate this panel, we have Joelle Foster, who's already right here, which is really fun for me. I get to like Vanna White you, not just the Yeti mug. Now, Joelle was on stage earlier but didn't get a formal introduction, so I'm going to do one for you. Yeah, and you're going to sit right here and act comfortable while I do it. So Joelle Foster, she is a co-founder and also the president and CEO of North Forge Technology Exchange. If you don't know what North Forge is, by the way, they're a technology incubator accelerator, and they also run the largest fabrication lab in North America. And that's what my St. Vital's counselor was talking about earlier, taking his kids to, that he was saying was really cool, because they've got 3D printing equipment there and many other things, but I won't drone on. You should go see it. They do free tours. It's very cool. Now, Joelle has spent the last 2 decades working with entrepreneurs all across Canada. Joelle is also a co-founder and a managing partner for the Women's Equity Lab. Again, something if you haven't heard of it, especially for the women in the room, very cool. The Women's Equity Lab is a fund meant to increase the number of women angel investors in Manitoba. So women, if you're curious, you can find out more about that later. Joelle helped support over 500 startups throughout her tenure here, helped them open their doors. It's either from prominent national startups like Skip the Dishes and Calia Flowers. And Joelle sits on the national board of the Women's Entrepreneurship Organization, we do, the Women's Entrepreneurship Day Organization. She's also a co-chair of the Business Administration Advisory Board for Red River College, Polytech, amongst other committee work. So, Joelle, since you have lots of spare time, why don't you run this panel for us? Okay, great, thank you.
Okay, hi. All right, so this panel here is getting insight into the Canadian IP landscape. Now I can't say IP without, yeah, thanks, Margot. Like, really, thanks. All right, so I've got a couple of questions, and I think I'll start off by asking all of you to introduce yourselves, your company, your organization, so that people have an idea of, because I'm sure after the panel, they're going to want to come talk to all of you.
So good morning. I'm Silvia De Sousa. I'm an intellectual property technology lawyer. I'm with Thomson Dorfman Sweatman, and I've been practicing for about 30 years. And the reason I've been around for a long time, as most of you could appreciate, it's a creative area, because you're all creative, you're all creators. There's a lot of passion and a lot of positivity, and I love working with people who are able to bring that to me.
And you're renowned in Canada as like one of the top IP lawyers in Canada. So I just want to say, as a woman, top IP lawyer, so just a round of applause.
Thank you.
Hi, my name is Ryan Dupuis. I'm a patent agent with Ade Company. The firm Ade Company has been around in various forms of partners for about 75 years here in Manitoba, and has a long history of serving clients in that specific area. My own background, I'm a mechanical engineer, is where I started, and for about the last 25 years I've been working there, helping inventors of the full suite, from the independent startup guys to established companies, various sizes, and that's what we do. Yeah.
Hi, I'm Robert Werbowesky. I work at the University of Manitoba as a technology manager. For over 20 years now, I've been in a field called technology transfer. First with the National Research Council of Canada, and now with U of M, which is basically patenting research and finding companies to commercialize it.
So you're getting those ideas off the shelf and getting it to commercialization?
From lab to market.
Lab to market, nice. So Silvia, I've got the first question for you. Why is creating an IP strategy important? So a lot of people, they hear about trademarks and patents, but they don't hear a lot about IP strategy.
So the bottom line is the reason why you want to have an IP strategy is it's going to increase the value of your business. And I had one of my associates students look at some research for me, and on a practical, not even on a legal, like on a business level. And in October 2023, there was a study done, and there's been a very profound migration of value going from tangible assets like buildings and inventory to intangible assets, which is intellectual property. It's a very good example of intangible assets. And so value currently is in intangible assets, and an IP strategy is going to help you protect your intangible assets. And the way I describe it to my clients is there's basically 4 pillars in IP. One is identify the IP, you all have it. But number 2 is you protect the valuable IP within your business, because you're not going to have all the time and the money to protect all of the IP you have. So we work with you on the IP strategy and what do you protect. The third is IP ownership, because if you don't have the ownership within the target company, you're going to have problems getting the most of the money for your business out of the value. And then the fourth pillar is commercialization and monetization. And an IP strategy deals with all of those pillars. And so the benefit is you increase the value of your business, and then the side benefits is for those in the room who want to flip your company or who need to get lending, dealing with venture capitalists or with banks, the IP strategy report that you get will assist you in fixing any deficiencies that we find when we're doing that IP strategy. So you fix it, and then you go to a prospective purchaser or a lender, and you'll maximize the value with them when you're negotiating.
And in IP strategy too, I think a lot of founders forget that those NDAs that they have within staff, and when you're hiring people and those employment contracts, I think a lot of people forget that that is part of the strategy as well.
Certainly. And so when we're doing IP strategies for clients, we're identifying your IP, but we're also asking about disclosure, which is what Joelle is talking about with respect to the NDAs, and then the IP ownership, which is with respect to NDAs, employment agreements, joint development agreements, collaboration agreements, license agreements. All of these agreements, depending on what you're doing, you want to have them in place with strong IP clauses, particularly because you want to make sure the target owns all the IP that's been created and also going to be created. We call those improvements in the future.
Thank you. So question for all of you, what are some of the common challenges that individuals face when protecting their intellectual property?
I can
Go ahead,
start. With patents, one of the big challenges is a lot of people are trying to apply for them. They're not easy to get. So just patentability in the first place. Keep in mind that a big market like US, there are companies not just in the US, all over the world are recognizing that as a big market. Everybody wants their piece of the pie. So yeah, the patent office is faced with thousands of applications all asking for their little piece of the pie. They have to be strict. They can't just give those patents away, or you end up with a situation where nobody can sell anything without infringing a patent. So that's the first hurdle. Is just you really have to. The bar's set pretty high, and you do really have to have something innovative just to meet that bar. The second perspective is the infringement side of it. It's great that you can get your piece of the pie and have a monopoly. That doesn't just getting a patent doesn't necessarily guarantee you can sell a product or commercialize a product. So you have to look at it from the other side too. What have other people patented, and where is there some white space to operate and commercialize? So that's just the sheer competition of the number of people applying for patents. That's where the difficulties come from, of just being able to get your piece and make sure you're clear to commercialize.
But it's still a good idea to go after the patent.
Oh yeah, you want your piece of the pie, but
just want everyone to know that, because
you have that. Be aware of that expectation that just because there's something a little bit new doesn't mean it's necessarily patentable. There's still a decent bar there of patent officers refer to it as non-obviousness or inventive step. That there has to be a significant leap forward to really get the patent approved typically.
Robert?
I think the challenge that I've faced the most is because I work with researchers who always want to publish and get the stuff out there, is that it got out there, and you can't. It limits what you can do once something is out there. So a challenge that I've always come across is it's already been published.
So what would you tell any researchers in this room right now that want to publish something?
Talk to me first. And it's really it's almost a niche for researchers, because you get lots of people with the opposite problem, the NDAs. I don't want to share my idea too early. Well, with researchers, it's like, don't share your ideas too early because we have to protect it first.
Sylvia.
And so just following up on both these speakers and the points that they've made. So I mean, what I tell my clients is, this is the disclosure issue. Do not tell people how your invention works unless you get a confidentiality obligation tied to that confidentiality. So if you're going to tell someone, the confidentiality obligation would be done through usually an NDA, or if you're doing an employee relationship, having a strong confidentiality clause within the employment agreement, or the contractor within your independent contractor agreement. And if you may be thinking, okay, that's great, and going back to Robert's point, that's great, but I want to publish. I mean, that's my goal. And so if you can't get the NDA, that's okay. Then we have the provisional patent application. And so get that filed before you start disclosing, before you start publishing, right? So now you have 1 year to do whatever you need to do. And as that 1 year comes closer, then we have a fulsome conversation, just to go back to Ryan's point. Okay, we've done further research, we've talked to people. Do we have enough here now to get a full patent application filed? Is there a brand new idea here that we have that we do a full patent? But don't forget about the tool of provisional patent application. Use it. It's not expensive. It gives you a year to try to figure it out.
I want to talk about trademarks a little bit because we get a lot of people that ask us about trademarks. They're like, I might not have a patent, but I want to do a trademark. So what does that entail, and does it really protect you? So any of you on the panel?
I could certainly speak to that. I got some stats. I wanted to see what the stats were for this panel for trademark filings by Manitobans. And it's dismal compared to the other provinces. And there's no reason for that to be the case. Patents are not, trademarks are not that expensive to file. And the reason why you want to file is really twofold. One is, if you get a registered trademark, you get a monopoly in Canada. And so the example, and some of my clients are in this audience, and they've heard this example. The example that I give to my clients is, if you get a registered, let's say you're a Manitoba business, you're using your trademark, your brand, your logo, your word mark in Manitoba, but you have hopes to expand across Canada. But none of us all have the money to go and expand across Canada within a week or two, or even 2 months. It takes a while. And so let's say you have a registered trademark and it takes you 5 years to get into the Atlantic provinces. And then you go there to set up business and you see someone's already using your trademark. Well, if that person started using your trademark after the registration date of your registered trademark, you can knock on their door and say, I'm here in the Atlantic provinces, I need you to stop. And they're going to have to stop. Whereas if you don't have a registered trademark and you go to the Atlantic provinces and someone's already ahead of you there using your trademark, you're not going to be able to stop them. So that's the big benefit of getting a registered trademark. And you'll have a number of different trademarks within your business. It doesn't mean you have to register all of them. Look at your house mark. Look at your design house mark and start there first. And then the other big benefit to getting a registered trademark is infringement. If you get a registered trademark, you get access to the Trademarks Act, which gives you additional rights to stop people who are stealing your trademark. Versus if you have a common law trademark, you don't get access to those rights. So having those two big benefits, again, increases the value of your business, reduces your headaches as you expand across Canada.
Thank you. Any other comments on trademarks?
We don't
No? Okay. Yeah. Yeah, okay. I like that. So Ryan, I've got a question for you. How does the patent application process work? What are the key steps involved for anyone in this room?
Yeah, sure. It's a pretty loaded question. I could maybe go on for half an hour, but we'll try and stick to the high points. For the most part, the first thing to keep in mind is patenting is done at a national level. So for the most part, we're talking about in Canada, Canadian patent done federally and protects you within the laws of Canada. But then, in other countries, U.S. or anywhere else, it's a separate application process, separate laws. Fortunately, most of these countries of interest are all part of treaties and have very aligned rules. So even though we're going through a patent process in Canada that might start with file a first document, eventually a year or two later go through some review process under Canadian laws, you usually expect the same kind of result from that review in US or other countries because the rules are very aligned. So you keep that in mind with your strategy, that you're kind of expecting the same kind of patents. The biggest point is the treaties between the countries, that picking countries isn't kind of the first decision on day one. Day one, as Sylvia already referenced, the provisional, it's get your date in the system. One document filed at one country, Canada, US, wherever, but most commonly something like a US provisional. You get that one date in the system, you're effectively patent pending worldwide for a year. So you got some time. You can focus on other things and get some commercialization feedback, any of those things, before you're getting to a point where you're being forced to kind of pick countries and make decisions from that. So yeah, first step is just that first few weeks to assess, is there enough to work with to get a first date, get that first document submitted, and that might just be a few weeks to get to a patent pending point and effectively internationally. The next major point is maybe working towards the 1 year mark. That ideally within a year you have a little bit of a strategy of where am I going long term, what are my markets, that'll be the next decision point at a year's time of what kind of countries are you looking at. The actual review and the debate on a per country level tends to follow after that, so often year 2, 3, 4 kind of, where you're starting to undergo review with the different patent offices. And so ideally at that point, and really throughout the process, you're kind of monitoring how is the technology evolving alongside the patent, is the patent still current? Often those first documents are kind of a brainstorming list of, here's 10 ideas I want to protect, but we don't really know the direction we're going yet. Well, that fine-tuning is kind of happening more at years 2, 3, 4 when you're actually undergoing the debate with the patent office. And that's where you end up kind of with the final patents. But there's lots of opportunity to, the full strategy tends to be more complex than that. There's lots of branch-off points where you can add on with improvements, file kind of secondary patents and things like that. But the high level is get that first date maybe in a matter of just a few weeks. Kind of target a year to make some decisions about where you're going with your markets, and throughout the process kind of monitoring, is your evolving technology still in line with the patents that you got in place, or do we need to keep updating things? But that's kind of the big picture, yeah.
Robert, do you have anything to add to that?
No, that's...
Okay. That was perfect answer. So what do you think some of the barriers are for people not filing these patents? Like, what do you hear the most out there?
Well, cost can be a big thing. That's a big chunk is just cost, and the other is getting the technology to a working point that you've got enough to work with. People often start with kind of a goal of, I want to solve this problem. Here's the problem I want to address. Here's the solution that I want to put forward, but they maybe don't have the details worked out yet. And to some extent, those details are part of what makes the patent. Just the idea of wanting to solve a problem or addressing a problem really isn't patentable by itself. It's getting into the details. Well, how am I going to do it? And not just in the short term to find that first solution, but kind of long term, what's the most commercially viable way to do this? So staying on top of that and really being able to pinpoint what you need to protect is an ongoing kind of hurdle to be constantly addressing throughout the process.
And I mean, we're here today because of the IP funding from ISED. Now that barrier of cost is gone. So we're able to, across Canada, this funding is able to provide $25,000 for the full strategy, and then 70% of patents and trademarks and copyrights, et cetera, are covered, 70%. But if you're a woman or if you're Indigenous, 90% of that is covered. So I'm just saying now, there's no excuses to contact these individuals out there. So let's hear about some examples of successful intellectual property strategies for startups or small businesses.
I could certainly speak to that. So examples of successful IP strategies. So number one, all IP is national in scope. There's no such thing as an international patent or trademark or copyright, for example. So going back to Ryan's point, ultimately at some point you're going to have to figure out, as you're evolving your business, like where am I making my money? What countries am I making my money in? And then file applications there. An ElevateIP program will give you funds, not just to protect in Canada. If you say to me, you know what, the USA is a key market, and for a lot of you it will be, there's funds for you to tap in to get patent protection, trademark protection, copyright protection in the US. And so national scope, and number two is just because you have, let's say, a copyrightable work, like a logo, don't think, oh, logo. Oh, based on what Sylvia said, oh, I guess only trademark, I could only use trademarks to protect a logo. No, use a multi-tier, multi-layer strategy to protect your valuable IP. So if your house logo mark is valuable to you, and you are providing and selling products in the retail market, the multi-layer approach would be, okay, I'm going to use trademark protection, I'm going to use copyright protection, and maybe I may be able to use industrial design protection. And so that strategy will allow you to deal with due dates. So trademarks, there's no expiry on trademarks as long as you use a logo as a trademark. But unfortunately, for patents and industrial designs and copyright, although copyright is very far in the future, but the other two, with patents, it's 20-year monopoly, for example. And so your multi-layer strategy will allow you to try to move that expiry date using different types of IP further into the future, so you can still have that monopoly as it relates to your competitors. So that's one example of an IP strategy that we could certainly use. I'm not sure if Robert and Ryan want to add to.
My first thoughts to that is, the ideal strategy is having as much information as you can to make those decisions at the outset. Programs like this really make that accessible to a lot more companies, so that's great. But yeah, it's just knowledge of what are competitors doing, where's the white space where I can avoid infringing patents, what can I patent, have I got enough there? So as much as you can resolve at the outset before you get too far into the process, before early patent applications that you file start getting published, and other commercialization steps lead to publication. Just having that knowledge at the outset to make those decisions is the ideal. That being said, there's a minimalist approach to an IP strategy too, which is we deal with a lot of problem solver types that they've already solved the problem, they've already got something working, they've already carried it through to something that just starting with that first patent to kind of secure that, worry about the commercialization strategy later once you've got that date. There's lots of success stories that way. In Boxer, to some extent, referenced earlier. It's that early IP that got filed. This is what got all the returns. That maybe the commercialization strategy didn't go the way they planned, but those things can be determined later if you got that first patent filed. So, one example of a more minimalist approach is just get that first patent filed. Particularly for the problem solver types that already have something working, is a successful strategy for a lot of companies.
Robert?
Yeah, I think something early in my career, we used to almost delay too long, because once you start the process, the bills start coming in sooner, but knowing your competition, it's kind of like, okay, how long can we delay? Is somebody else going to scoop us? But as Ryan just said, I've had it in more recent years. I've had a number of files where somebody beat us to it by months, and you don't find out about it because provisionals aren't published, and another research group somewhere else just beat us by months. So it's a tough call in terms of strategy. When do you just say enough is enough and just file?
Do you have any interesting, I guess, not necessarily stories, but almost lessons, a lesson that you might be able to share to the audience of maybe what to do or not to do, something that's maybe happened in the far past?
Just to me, two things. Like IP ownership, I know for some in the audience may think, oh, just IP ownership. But I've had files where the deals died because of IP ownership issues. Like, you need to make sure that all the IP is owned by the target, by your company, and not your employees or your contractors. And unfortunately, people don't know the law, and so they think after paying an employee or after paying a contractor that the company owns the IP that the employee or the contractor created. But in some situations, that's not the case. And these sort of situations come up when you've decided to flip your company, and then you have the prospective purchaser coming in to do a bunch of due diligence, and they're going to be looking at all your agreements. They're going to be asking about who was involved in the development of your technology. I need a list of all the employees and the contractors. And then they're going to ask, well, how did you tie up the IP ownership to the company? And then they're going to say, okay, well, you have agreements, that's great, let me review them. And so you want to make sure that, and this is where the IP strategy comes in. We do this all within the IP strategy. Like, you don't want them then to review an employment agreement or even a contractor agreement, and the IP doesn't stay with the company. It's either a joint ownership relationship, or it's the contractor that owns all the IP. And so that's a big problem. And the IP strategy in this Elevate IP program will help you with that. So that's a big issue, I think, that people seem to sort of put out on the side. But that's from my experience, that's where the deals have been lost, is the IP ownership.
And that's why we had Silvia do up our employment contracts and our contractor contracts. They are ironclad. Yeah. Do any of you gentlemen have some interesting stories you could share?
I kind of jumped to the same thoughts as Sylvia, really. Just ironing out those details before you get too far into a relationship. Even partnerships, two people starting a business together and put their names as co-owners of a patent, that by itself isn't enough to tie you together. Co-owners of a patent just means that you both have equal opportunity to commercialize under the patent. So that relationship dissolves, and one person goes off, makes a big success. He doesn't owe the other party anything. That just the patent, just co-owning a patent doesn't dictate anything. So all these kind of agreements, who's involved in the process, even the inventor who starts out with his first kind of worked out most of an idea, but then doesn't file a provisional for staking his claim for stuff that he owned individually. Waits to get a collaborator on board to kind of fine-tune things, and they're back into this situation. Two co-owners, and they're not necessarily tied together just because they're sharing some IP. So yeah, same kind of thoughts. The big mishaps is just getting all these relationships sorted out before you get too far into the process.
Yeah, and as I said before, my heartbreaks have always been, you published. And maybe not even, it often happens with students posting thesis in some back channel something, or even social media, heaven forbid, kind of like, look at what I'm doing in my lab. No, let's not look what you're doing in your lab yet.
And if someone shares that without that person's knowledge, it doesn't matter. It's still out there.
It's still out there, and I don't know if Ryan touched on this earlier. Once something's out there, you're really limited in where and how you can protect.
Yeah.
Well, so I'm going to go off script a little bit because I'm hearing this. So X, Twitter, I know that X mark, Microsoft has a patent on it, some other organizations. How is he able to get away with that? Is it because he has billions of dollars? He can keep fighting the lawyers?
With respect, not a patent, like a trademark on the X.
Yes.
Okay, so number one is he may not have a registered trademark on the X. Number two is getting a trademark on just one letter, very difficult, because the premise and the foundation of trademark law is distinctiveness. And so a trademark has to be inherently distinctive in order to get registered. X is not inherently distinctive. However, there's an exception. It's called acquired distinctiveness. But in order to acquire distinctiveness, what I tell my clients is you should have about minimum 3, best 5 years of really getting that X trademark out into the public, like really branding, like galore, like get it out there. And then we could try to go to the trademark's office and ask for a registered trademark on X using affidavit evidence showing all of the sales and the marketing channels and the marketing collateral that was used to indicate to the trademark's office, yes, it's not inherently distinctive, but we've acquired it. So what does that really mean? It means that when someone sees X, they think automatically of the social media platform that allows messages to go. So I suspect they don't have a trademark on the X. And the reason why there may be other players, let's say it's not X, let's say it's Aldo shoes. Aldo could be is a trademark. I could use Aldo for shoes. Joelle could use Aldo to provide housewares. You could use Aldo to provide a social media platform. That Aldo trademark could be registered 3 times on the trademarks register for all 3 of us, and that's okay because we're not providing confusingly similar goods or services. It's the moment that you are using a trademark that's causing confusion, someone else already has that trademark, that's when you get into the infringement, the passing off issue. But if it's different goods and services, different consumers, different market channels, there's good arguments to make that there's no confusion, and all three of us could have Aldo on the trademarks register.
Very complicated. This is why we need lawyers. There's no jokes today about lawyers. We need lawyers for IP. I've just got to say, I'm trying to follow all that, and I'm like, okay. Okay, I know we don't have too much time. What are some of the interesting trends that you're seeing around intellectual property right now? All of you.
I could certainly answer this, because the exciting trend is data. And I think we all have heard data's the new oil. I say this to you because I've been doing this for 30 years. No one talked about data when I started 30 years ago. And data's really been talked about within the last, for sure, 5, maybe 8 years. And don't think, oh, I can't use my data. Like, try to monetize it if you can. And you have to be creative on how you're going to do that. And so we can certainly work with you on that. But that's a big trend, I think, is monetizing your data, creating another income stream for your business.
On patents, maybe a little bit related to data, but at kind of software is maybe the biggest trend. I think going back 20 years ago, it was very, the software guys were very open source. Patenting's not for us. Then there was a bit of a movement where they started trying to patent, and then the patent office said, whoa, there's nothing here, there's no technology, there's no physical thing. So that was very, no patents on that whole space. Now it's kind of come back to a balance point of recognizing that there is still some technology and some innovation, even though it's software. And that seems to be a big trend of a lot of patents now. Probably the majority that I'm working with has to do with software, and specifically managing data. So like the ag manufacturers locally that were patenting springs and gears and things like that. Now it's all about, well, now that we're out there and we have all these sensors collecting all this data, what are we doing with it? How are we communicating this data? How are we making management decisions based on data? So all that software realm that is a very active field, and there's a lot of value in just how we're managing that data. What do we do with all that? And it's a lot of space to patent right there.
And in there is, there's so many app developers out there trying to say, and coming and saying, oh, I want to patent this. As much as big companies have data and significant niche in software, maybe apps aren't the best thing to patent. Right? What they're doing, there's other ways, trademarks and branding, et cetera, where your IP strategy involves everything except patenting.
Could I just add, with respect to data, and we're seeing this with ChatGPT, where they're being sued. So monetize your data, but there's 2 ways of handling IP. You're either an owner, and if you're not an owner, you want to be a user, which means, in legal terms, it's a licensee. And if you're not an owner and you're not a licensee, and you're using someone else's IP, then you're an infringer, and that's how you get sued. So so monetize your data, but you have to make sure you have in place the proper agreement that allows you either to be the owner of that data, and if you're not the owner, that's okay. You want to be a user, but you got to get that right to be a user, and that's done through an agreement.
Okay, thank you very much. The 3 of you are staying around, so everybody can come up and chat with you throughout the day. Thank you. Thank you so much.
Thank you.